So tonight, the focus of Special Counsel Bob Mueller's probe is on three people. They are all connected to one man, longtime Donald Trump confidant, Roger Stone. One of them is a radio host identified as the back channel to WikiLeaks. Another is a friend of Stone's known as the Manhattan Madam. And the third is a former aide of Stone's named Andrew Mueller, who refused today to comply with a subpoena, so he is now facing a contempt charge. Why dodge if you have nothing to hide? Let's get after it with Mueller's lawyer, Mr. Paul Kamenar. Welcome to Primetime, Counselor.
Thank you, Chris. Good to be here.
Good to have you. Let's test the case. Is this about hiding? Is this about ducking the truth?
Absolutely not, Chris. This is a constitutional challenge to the lawfulness of the special counsel Mueller. What we did was challenge his constitutionality on the grounds that he was not properly appointed under Article 2 of the Constitution. And we said that if you're going to appoint him under the Constitution, he has to be appointed by the head of the department.
Right.
And the head of the department is Jeff Sessions, not Rod Rosenstein.
Right. You made that objection. It was ruled on by the judge in a 90-plus page decision that every expert that we've had on about it and that I've talked to in the reporting feels confident about it. Let me put up the key excerpt for people, and then we'll talk about why you're still testing it. This is what the judge said. Multiple statutes authorize the special counsel's appointment, and the official who appointed the special counsel had power to do so. So, for these reasons explained in further detail below, the witness's motion to quash the subpoena is denied. In other words, you've made the argument, it's been weighed and measured and found lacking, and while the AG didn't appoint the special counsel, he recused himself. Rod Rosenstein, someone who is directly answerable to the president, did. So where's your issue?
Very easy, Chris. Jeff Sessions recused himself from the investigation. He did not recuse himself, and he could not recuse himself from the Constitution, which requires the head of the department to appoint the special counsel. But what you had on the screen there was a different argument in terms of, is there even statutory authority to appoint a special counsel?
The judge said yes.
This judge said yes. There's another judge who's also hearing this case in the same court, and at the argument she had last week, she said these arguments are, and this is her word, compelling. Now, she hasn't issued her decision yet, but you have to remember,
compelling
Chris.
Compelling in what context, Counselor? Compelling political questions?
No, compelling.
Because this judge said that too. These are interesting questions, but they are not legally sufficient.
No, the other judge said that the statutory argument was a compelling argument in terms of the lawfulness. In any event, Chris, these are one judge in our case, and the reason we had to not appear at the grand jury was so, in fact, we even asked this judge to hold our client in contempt of court, because under the rules of appellate procedure, you can only appeal a contempt citation.
Right.
So we had to.
So you had to be in contempt in order to trigger the appeal.
That's right. So it's not hiding anything. Okay.
I get you. Well, hold on. I get you on the procedural argument. I'll give you that. We'll stipulate to that for the point of this discussion. However, why isn't it about hiding? This guy is not some constitutional, reform zealot. If he has nothing to hide, give the documents over that they say, give the testimony. Roger Stone says Andrew Mueller has no knowledge of or evidence of Russian collusion or WikiLeaks collaboration or any other illegal activity. Then testify.
All right. Here's the thing, Chris. He already talked to two FBI agents for a couple hours, answered all the questions. And then they asked for all the documents. He gave them all the documents.
We didn't give them all of them because they're asking for more documents.
Well, not really, Chris. They're not asking for more documents. They're just asking him to testify about this. And now he is.
But there was a June deadline that he had to meet in handing over additional documents.
And he did on June 20th. He did.
So he gave them everything that they asked for.
Exactly.
There's nothing outstanding.
That's nothing outstanding. So all that's left is, okay, go into the grand jury, and he has a principled issue here. He himself is a very staunch libertarian. He worked on Gary Johnson's campaign in 2016. He didn't vote for Trump, doesn't like Trump's policy, so he is committed for a restricted government power. And what we have here with Robert Mueller is basically a super U.S. attorney, more powerful than the regular U.S. attorneys, and regular U.S. attorneys.
He's directly answerable to Rosenstein, so how's he more powerful?
Okay. Well, so are other U.S. attorneys, but listen.
Right, that's my point. So how's he super?
Well, he can file cases in any jurisdiction in D.C., Virginia, New York. Your regular U.S. attorney cannot. But listen to this, Chris. All these U.S. attorneys are nominated by the president, appointed by the president, with the consent of the Senate. So here you have Robert Mueller acting like a U.S. attorney at large, a super U.S. attorney, and he hasn't been gone through the confirmation process. So that's why our two arguments is that if he's an inferior officer, Jeff Sessions has to appoint him. If he's a superior officer, the Senate has to confirm him. And he's not really being supervised closely by Rosenstein. He's basically given free rein. He's indicting Russian foreign agents.
He has a specific mandate. Rosenstein reviews it. We've seen that decisions have been made to parse out different things that Mueller started looking at and then went to the Southern District so that, there's been a judiciousness in terms of what he can do. I don't see why you think that's a clear question.
Well, no, it is, because in terms of the supervision, Rod Rosenstein basically does not effectively control the actions.
Why not?
Well, because you see that there has been no limits on Mueller's jurisdiction and authority. He is now going after a Manafort, which is has nothing to do with the Russian investigation.
But in the mandate, it says that things that arise from it.
Sure, and it can go as far as you want on that, but we're still challenging whether or not he can lawfully exercise those powers under the Constitution.
Well, what I'm saying is the judge ruled on this, and you're saying you're not satisfied with the ruling, even though
yes.
This could easily be dispensed with, and Mr. Miller could go on with his life if he has really nothing to offer up. This seems like a potential distraction of process.
It's not a potential distraction. The Constitution is never a distraction, Chris. These are important principles.
Right, but you're assuming it's unclear under the Constitution. This judge says it is not.
Well, that's one judge. You have the Court of Appeals, and you have the Supreme Court. Chris, remember in Morrison versus Olson, you had that case in terms of the independent counsel, where the district judge ruled he was unconstitutional, and then, by the way, they were held in contempt of court too in order for them to appeal it.
But you remember what the issue was in that case, right? It's not the same one that you're bringing.
It's still the same issue as whether or not in that case, the independent counsel satisfied the separation of powers in the appointment clause. They ultimately ruled that they did, but in Morrison, Justice Scalia dissented, and that decision, by the way, is basically going to be overruled if it already has been. Many jurists, including Justice Elena Kagan, said that Justice Scalia was right on point on this. So that decision
but you
really is not much.
But you had a majority decision that went against what you're arguing right now.
No, not on point, because we had several other arguments that were not addressed in Morrison, and that dealt with a different issue of whether the three-judge court can be the appointing power. So it is a very weak precedent at best, and the Supreme Court has the last word on this. We think that...
Is there any case that has ever ruled the way you want to see it?
Well, this is a precedent-setting case, so by definition, there isn't. But we have a lot of arguments that we make to show that we do have a good case. The judge recognized he was legitimate.
If you lose, will he testify?
He'll have to testify if we lose, of course.
So he will not hold out, because he's a libertarian, maybe he would just hold out on principle.
No. He's been cooperating with the special prosecutor, special counsel in this case. So he's not going to be a recalcitrant witness. We're just standing on principle, Chris. This is the Constitution that's involved, and that's what our main interest is.
Well, both are true, right? He is a recalcitrant witness, but you're saying it's because of principle. Well, he won't testify. That's what I'm saying.
He won't testify,
that's
but
by definition recalcitrant.
Well, usually a recalcitrant, I'm not testifying for no good reason, where I just don't want to talk to you.
Well, right, but that's debatable because we don't have any precedent here to justify
the argument you
want to make. But we'll see how it goes.
Well, the courts stay the contempt, by the way. And the case law is that if you raise a good issue, a constitutional issue, the judge usually stays that case. So that shows that...
Fair point.
Okay.
Fair point. It's Friday night. I'll let you end on that one. Counselor,
thank you.
Paul Kamenar, thank you for coming on. As we learn more about this case, do me a favor. Please come back. All right? Good to have him on the show.